You use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Ten Eyck. Blah, 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 blah.
I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words. What time, dumbass? 3 contempts.
Hey, court watchers. Judge Ten Eyck is hearing a custody case where the father's attorney has come with 5 separate motions: a drug test, a psychological exam, and more. The mother has no lawyer. Hers withdrew and she's representing herself. Most people assume that if you can't afford an attorney, the court gives you one. In a custody case, that's usually not true, and the mother is about to find out the hard way. What starts as a routine discovery hearing turns into something else entirely once she starts answering the judge's questions. Every answer digs the hole deeper, and then she does something on camera that leaves even the judge choosing his words carefully.
Good morning. How are you all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir.
Get us off of your docket is what you could do. Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes,
It's
sir.
specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah,
And
blah.
stop talking. You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me, or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions. And then we ultimately never got a response, and she filed a motion for
She
protection.
got plenty of responses. Objection.
What's your objection? Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents Cody and all fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So, Ms. Kimball, why don't you just go ahead and finish telling me what? So you said that you're wanting a drug screen, so drug test, and do you say psychological or psychiatric? I thought you said
a psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition and for attorney's fees for $1,500.
Okay. All right. So, Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll fell for marijuana.
When was the last time?
But I'm happy to take it on
When was the last
expense.
time you took marijuana?
I use marijuana daily, all day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
Okay.
So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense,
Stop.
but
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can
Kimball.
just, if you're gonna use my last name, that's fine. Just say Judge Ten Eyck. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Ten Eyck.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I can. I would propose.
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo,
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
What date are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What do you
I
anticipate?
would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempts.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
Stiles, that question is to you. Never
I
mind.
said what
I'm not
time?
gonna let you
Time,
pick.
date, you know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation. So, in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record that she opted out after flipping me off. I won't comment. So I'm going to grant the request for August the 30th at 9 a.m. in your office disappeared. I will sign an order that orders that the deposition take place. Let me go back since she left and I heard her responses. I was going to take testimony from your client and from her. Do you need any testimony from your client about the drug screening? So I haven't read the custody evaluation, but if they're requesting it, your client's asking for it, she's whether she's going to pass or fail is not the determinative factor, because you may want it to see if there's something other than marijuana. So I'm going to grant that request. I don't need testimony from a client about that. In terms of the psychological evaluation, I'm just going to allow your argument.
Your Honor, I think based on the presentation today of Ms. Stiles and the custody evaluation report from Mr. Bouchard, I think it's apparent that there could be some mental health issues that would obviously impact custody and access to the child. So we believe a psychological evaluation would be necessary. Furthermore, Ms. Stiles is not in possession of any of her children at this point and has not been paying support on ALA for a little over a year now. And so we would be requesting, she's also received the tax stimulus funds and income tax returns for claiming the children. So we would ask that the expenses be put on Ms. Stiles to pay for that.
I'm sorry, to pay for what part specifically?
For the drug test and the psychological evaluation.
Because she's been receiving that money.
Yes, sir.
Okay. I think I know the answer, but I don't want to assume. Mr. Parnell, have you received any of that money? Does she provide even $100 to you?
No, sir.
Okay, thanks. I was taking your attorney's representation as being true, but sometimes it helps me just to understand. Okay, in the motion to compel, did she provide any response? She had an attorney as recently as last month.
There were
recently as the last 3 weeks, but it's been a couple of days.
there were some, I've allowed 2 extensions by agreement, Rule 11 agreement. The responses we got were some partially answered interrogatories, but they weren't unsigned. But for the interrogatories, the documents, everything was just kind of blanket objected to for, I believe it's for harassment was the objection. So, and we received no documents at all. Ms. Bertrand did represent that there could be some documents in her office, but that was when she was still on the case.
And were there objections made to the interrogatories?
Yes, sir. Objections to undue burden, unnecessary expense, harassment, or annoyance.
Okay, let me pull them up. Okay, so in reviewing them, one is about persons expected to testify at trial, identity and location of employers in the last 2 years, identity of people she's had an intimate relationship with, mental health and physical health care providers or objections, but then that was actually answered, but just names, not any address or phone numbers or anything like that. Income questions not answered. Monthly living expenses. It says litigation, auto payment, cell phone. Did you get anything? Did you get any numbers, or is that all you got?
That's all we got.
She objected to why the prior order should not be modified. She objected to, so it says that there's an objection in time and place, and that the document that she'll produce the requested documents at O'Neill Wysocki PC at their address upon reasonable notice. So did you and Ms. Bertrand have a conversation about that?
Yes, I tried to have a conversation about that, and it was not well received. And she also pointed to the fact that she had filed a protective order as well. And so she did not want to deliver any documents or allow me to inspect until the protective order was heard.
September 29th, the request for production was sent. Response was provided November 20th. Okay, there's the part about the agreements to extend. There's a mention of respondent refusing to comply with the child custody evaluator. Since I'm not taking testimony from your client right now, are you wanting that to be admitted?
She ultimately finished the child custody evaluation and did comply.
Okay, so I'm just trying to clarify. I'm not trying to get a yes or no, I'm trying to understand. So you referenced earlier that the request for the drug screening and the request for the psychological evaluation were contained in the custody evaluation.
Yes, sir.
Are you wanting that to be admitted?
Yes, sir. I was going to have Mr. Bouchard there to testify at trial.
14 days of this order, 14 days of sorry, it says 15 days. Within 15 days of today, if she petitions the court, I may reconsider it. At this point, I'm just going to grant it. So you can just include in there that I granted it. The deposition about dates we addressed. So that's August 20th, your office at August 30th, August 30th, 2021 at 9 a.m. in your office. In terms of the request for the psychological evaluation, I'm granting that request. You're requesting that Dr. Lammers do that?
Yes, sir. That was the recommendation in the custody evaluation.
Okay, so I'm going to grant the motion for psychological evaluation and grant the second paragraph where it asks that the respondent, which is the mother, Ms. Stiles, pay for her psychological evaluation. Okay, so drug test, psychological evaluation, motion to compel, deposition, and attorney's fees. Those are the 5 things that I heard you say at the beginning, and those are the things that I have in the file. Was there anything else?
No, sir.
I wish you all the best.
Thank you, Judge.
Here's what most people don't know. People assume if you can't afford a lawyer, the court gives you one. Not in a private custody case. In Texas, that only happens if you're facing jail for contempt or the state is trying to terminate your rights. This mother was facing neither, so she went up against a board-certified family law attorney alone, and going it alone doesn't lower the bar. You're held to the same rules as a lawyer. She objected to the discovery as harassment. The judge overruled her and made her answer all 12 questions. She refused the drug test. The judge noted that in Texas, family court, refusing one can count as a positive result. She still lost all 5 motions and $1,500 in the other side's fees. Not because she smoked, but because she argued the wrong things and refused to answer. The judge never raised his voice once. So here's the question. With your kids on the line, could you keep it together and just answer the judge? Drop your answer in the comments or respond. I read them. If this breakdown helped, hit like so more people see it and subscribe for the next case. Stay tuned. The next one's worth it.